Thank you so much, Janice, for inviting me to this conference and for having me speak today. It's really a privilege to be here, and it's been very inspiring already. For about the past 4 years, I've devoted a substantial amount of my legal practice to challenging the constitutionality of sex offense laws and policies, mostly in Illinois, but also in Wisconsin and occasionally other states in the Midwest. And as I think anyone in this room knows, this work can sometimes be frustrating, discouraging, and disheartening due to all of the legal barriers we face to success, the public opinion that sometimes impedes our work, and the political barriers to effecting change. Anybody who does this kind of work will face setbacks that can be very discouraging, and as several of you already know, I started this year, 2019, with a setback that really shook my faith in doing this work and in our ability to effect change. We filed a lawsuit in Illinois challenging the state's residency restriction law, which imposes 500-foot buffer zones around schools, daycares, and playgrounds. And the particularly horrible thing about Illinois' residence law is that it does not grandfather in existing residences. So someone who has a sex offense conviction in their background, who goes on to live a law-abiding life, establishes a home with their family, can be forced to move out of their home on short notice if someone decides to open a daycare down the street from them. We had 2 clients who were given notices that they had to move out of their homes. And we filed a federal lawsuit to obtain an injunction that would allow them to stay in their homes. Our clients, of course, didn't even know that someone intended to open a daycare near them, and they hadn't done anything wrong. And we received a really terrible decision upholding the constitutionality of that law. And I found that really, really discouraging. That decision was upheld by the 7th Circuit Court of Appeals, and the United States Supreme Court didn't grant our petition for a writ of certiorari. So that shook my faith a lot. But when I feel really discouraged in this work or overwhelmed, I often return to the idea that that was just one battle, and this is a much bigger movement than that. And in the aggregate, the work of everyone who's in this room, the people and families who are affected by these laws, the lawyers, the advocates, everyone who cares about these issues. In the aggregate, we're going to turn the tide, we're going to make a difference, and we will make change happen. So it's been extremely inspiring to be here with all of you for the past day and hear about the work that you're doing. And so I'm really pleased to be here. Janice ended her comments yesterday with a poem, and one line of it really resonated with me, which was, I can't do everything, but I can do something. And I think that that's what we're all here to do, is do something that we can. So I'm excited to share with you a story about a small victory that we had, the issue we decided to work on, and we were able to be successful on as part of this journey. Okay. In August 2016, my co-counsel Mark Weinberg and I received a letter from a man named Alfred Alkema. And he was imprisoned in the Illinois Department of Corrections, serving a 5-year sentence for a sex offense. His sentence of imprisonment was to be followed by a term of community supervision called mandatory supervised release, and he was given an indeterminate amount of mandatory supervised release called 3 years to life. So it was up to the Department of Corrections how much time he would have to serve on supervision after he got out of prison. But he alerted us to a very disturbing situation that he was in, along with many other inmates. He explained that the Department of Corrections will not actually release someone from custody of the prison unless and until they're able to identify an approved host site at which to live while they're on MSR. He told us that he didn't have any money to pay for a host site. He didn't have any family who could afford to give him a place to live or help him rent a place to live. And he told us there were no halfway houses in the entire state that would accept someone who had a sex offense conviction. And then most disturbingly of all, he told us that because his term of MSR was indeterminate, meaning that it could be as short as 3 years or it could be as long as life, he could potentially spend the rest of his life in prison simply because he didn't have money to pay for a place to live. And this is what he wrote in his letter. All the time the inmate spends in IDOC waiting for a host site is dead time. If a person cannot find a host site that IDOC is able and willing to approve, very difficult, they will serve the entirety of their MSR term behind prison walls. A 3 to life inmate will spend life in IDOC on MSR. And when we read this, we thought it couldn't be true. We could not be holding people in prison for the rest of their lives who'd only been sentenced to a year, 2 years, or 5 years. But we thought it was a very serious issue, and we started to research it. And we discovered that not only was it true, but there were over 250 people who were already in this situation of being held in an infinite loop of imprisonment simply because they could not identify a place to live. And these people were serving potential life in prison that they were never sentenced to by a criminal court. So I want to tell you a little bit about what we discovered about how Illinois law was working and how we challenged it in court. So I'd say the story of how this all came about is a useful microcosm for how all of these laws came to be so bad. And that is that no one passed a law that said, hey, let's administratively keep poor people in prison forever. No one passed that law. No one considered that that's what they were doing. What happened was very incremental. So the state of Illinois passed more and more laws making terms of mandatory supervised release longer and longer. Then they passed more and more laws making it harder and harder to find a place to live. Then they passed laws making it harder and harder for private charities to operate halfway houses or other forms of free housing. And then in the aggregate, that's how we got to this completely untenable and unconstitutional situation. People are stuck in prison forever with no hope of getting out. And I think that is the story of how things came to be so bad around the nation, is that no one passed a law saying, let's marginalize people and put them on the outskirts of society, make it impossible for them to get places to live, places to work, to be with their families. They passed a lot of laws, each of which, if you look at it uncritically and in isolation, sounds like it might be reasonable. Okay, so first I want to explain how this 3 to life MSR term works in Illinois. Anybody who is sentenced to serve a term of incarceration in the Illinois Department of Corrections also receives a separate sentence of mandatory supervised release. MSR is a little different from traditional parole. And the way that it's different is that it's not early release from an incomplete prison sentence, so you're not getting out into the community to finish serving your prison term. It's a separate sentence of community supervision that only starts after you complete your prison sentence. And in Illinois, people convicted of most sex offenses, many sex offenses, receive this indeterminate term of mandatory supervised release called 3 years to natural life. The Illinois Department of Corrections requires anyone with a registration requirement to obtain a host site at which to live before they get out of the IDOC on MSR to start serving their time in the community. There's a couple of reasons for this, but one of the main ones is that most people who have a sex offense conviction are required to serve at least part of their MSR time on electronic home monitoring. And that's interpreted to require a home at which to be monitored. But because it's so hard to find a host site, at any given time, there are 1,200 to 1,300 people in the Illinois Department of Corrections who are there on technical violations of their MSR. And that is almost always inability to find an approved host site at which to live. A lot of these people who have a determinate amount of MSR, meaning they have a year, 2 years, 3 years, just decide to serve the entire period of their MSR in prison, either because it's too hard to find a host site, because they can't afford a host site, or their family just doesn't want to pay for a place for them to live. So they just max out their time, and then after serving an extra 1, 2, or 3 years in prison, they get out with no kind of supervision at all. But for people with this indeterminate sentence of MSR, that time never starts to run because there is a state law that says the term of extended mandatory supervised release shall toll during any period of incarceration. And that means that until someone finds a host site, gets out of prison, and starts serving their MSR in the community, that time counts for nothing. It's as if they've done no time at all. So their parole time never starts to run. And that's why people like Alfred, who wrote to us in August 2016, are potentially facing life in prison, even though they weren't sentenced to that. Why is it so hard for people to find a place to live? Why were so many people stuck and unable to find a place to live? Well, there's a couple of reasons for that. The first is that the Illinois Department of Corrections, through their parole division, has the sole authority to decide whether a host site should be approved. And there's a lot of things they take into account in making that decision. One are statutory requirements imposed by Illinois law. Two are policies that have been implemented by the Illinois Department of Corrections. And then three is the parole agent's own discretion to decide whether the host site is a good place for the person to live. So I'll tell you a little bit about each of them. State law imposes a 500-foot buffer zone around schools, playgrounds, and daycare centers that applies to everyone who's been convicted of a sex offense involving a minor, including child pornography offenses. For people who are on mandatory supervised release for a sex offense, there is a state statute that says they may not live, quote unquote, near beaches, movie theaters, parks, swimming pools, any other places where minor children congregate without the prior approval of an agent of the Department of Corrections. So that leaves in the hands of the Department of Corrections investigators to decide whether a place is, quote unquote, too near a pool, beach, etc. There is a state law that says you can only have one person with a registration requirement per address. So that means that you can't live in the same house with someone who has a registration requirement. Someone seeking to parole for a sex offense cannot live in the same apartment building, apartment complex, as another person who has a registration requirement. So even if you find a place that complies with the near restriction and the 500-foot restriction, if somebody else has gotten there before you, too bad, you can't go there. And then finally, there's this requirement of electronic home monitoring that is imposed by state law, which says that you have to be on an ankle bracelet that measures your distance from a beacon that is located in the home, so that they can monitor that. Okay, the next source of restrictions are IDOC policies. Now, they've taken this statutory restriction of one registrant per address, and they've interpreted it quite broadly. They interpreted it to apply to trailer parks. Even though there was no statutory reason for that, they've said, we're only going to allow one registrant per trailer park. So, if you have the good fortune of finding a trailer park that complies with all of the 500-foot rules and everything else, and it's a huge trailer park in a rural area, you might be 500 feet away from the next closest registrant. Too bad you can't go there because they're calling that one address. They've also decided that if a landlord owns 2 apartment buildings that happen to be next to each other, we're going to call that a single address, even if they have separate addresses, and we're not going to let you go there. There's another registrant always there, also there. 500-foot rule. By statute, it only applies to people who have a conviction involving a minor. Department of Corrections has decided as a matter of policy that they're going to apply it to people whose victims were adults. The Department of Corrections will not allow a registrant to go to any host site where there is Wi-Fi, internet, computer, internet access. So this, of course, is a huge barrier to people's own families being able to take them in, unless they're willing to completely give up the internet, sometimes even smartphones. And then, for people who are married or have families, there's a particularly terrible restriction that they will not let a person serve their time at a host site where any children reside or visit, including the parolee's own children. So you may have a spouse and a child who are eagerly anticipating your return home, happy to take you home, but you can't go back to your own house unless you are willing to move out your own child, to move them somewhere else. And then, adding to all of those restrictions, we have parole agent discretion. And host sites can be denied by a parole agent for many reasons, some of which seem whimsical and are at the total discretion of the parole agent who goes to investigate the host site. So I've had clients who have said a host site was denied because when the parole agent came there, they observed that there were children playing in a backyard at a nearby home. There are parole agents who have said, I don't want you to live with a dog or another pet. That pet is too cute. It might attract children. The presence of children's items, even if they are, there are no children at the address, if you have toys or children's books, that, for instance, if your grandmother wants to take you in, or your mom wants to take you in and she has toys for her grandkids when they come visit, that might lead to denial of the host site. Any items that the parole agent just doesn't like, a safe, binoculars, a gaming system, that could lead to denial of a host site, or really anything else that the parole agent sees in his unreviewable discretion to be not suitable. That can all lead to denial of a host site. So it's extremely difficult to find housing, even if you have money of your own and a loving family that will search for the housing for you. And is willing to pay for it. But then, it gets even harder because there is absolutely no option for someone to go to if they don't have money to pay for their own housing. Or for instance, if you can't go live with one of your family members because of all these other restrictions, you are stuck because there is not a single halfway house in the entire state of Illinois that will accept someone who has a sex offense conviction. And but this happened because the state passed a law that any halfway house that's going to accept someone with a sex offense conviction has to have 24-hour security. And that became a very expensive requirement for these charitable halfway house providers to meet. And the state of Illinois also got very behind on paying its bills, as many of you probably know. And so they all just couldn't afford to do it, so they all stopped accepting people with sex offense convictions. Department of Corrections will not allow a registrant to use a homeless shelter as their host site. The Illinois Department of Corrections deems anyone with a sex offense conviction to be ineligible for work release programs that might actually enable them to save up some money to pay for their own housing. There's basically nowhere you can go to establish a host site outside of prison unless you have money to pay for it. In the course of doing this case, I took the deposition of the Deputy Chief of Parole for the Illinois Department of Corrections, and this is what he testified to. I asked him this question. Is it possible for a sex offender with an indeterminate MSR term who A, does not have money to pay for his own housing, and B, does not have family or friends on the outside who can pay for his housing, to ever get out of the Illinois Department of Corrections? And he answered, never say never, but using those criteria, no. So, needless to say, we sued. We filed a class action lawsuit on behalf of people who were subjected to these policies and laws, who were unable to get out of the Department of Corrections because they couldn't find an approved place to live. The named plaintiff in the case is a man named Paul Murphy. He was convicted in 2012 of a single case of possession of child pornography. His initial sentence was 36 months of probation. It should come as no surprise to anyone in this room that being convicted of possessing child pornography greatly disrupted Paul's life. He lost his job, and soon thereafter he lost his housing and became homeless. After serving 18 months on on probation in the community, he was revoked because he was homeless and he was found to be sleeping in a doorway that was deemed to be too close to a park. And that was found to be a violation of his probation. So that led to him being sentenced to serve the rest of that time in the Illinois Department of Corrections, to be followed by a period of 3 years to life of mandatory supervised release. Of course, if you are homeless when you go into prison, your situation does not improve by being imprisoned. And needless to say, Paul has not earned money, saved up money to pay for a house when he gets out. So he's been eligible for release on MSR since March 2014, but as of today, he is still in prison because he doesn't have a place to live. You know, that sounds really depressing, but it gets better. Okay, so I will just talk briefly about the legal claims that we brought to challenge this law in this situation. So our first theory was that this violates the 8th Amendment. And we thought it violated the 8th Amendment in 3 ways. One, it was a form of cruel and unusual punishment because it was punishing people simply for their status as being homeless and poor. 2, we claimed that the Illinois Department of Corrections was acting with deliberate indifference to our clients' constitutionally protected rights by denying approval for host sites, knowing that the consequence of that would be indefinite imprisonment. And then 3, we claimed that continually imprisoning someone, potentially for life, just because they can't find a host site, constituted cruel and unusual punishment because it was grossly disproportionate to the crimes for which our clients were convicted and the sentences they received. Second, we claimed that this system of laws and policies violated the Equal Protection Clause because it was essentially treating people differently based on whether they had money or not. Third, we claimed that it violated the 14th Amendment's guarantee of substantive due process because we said you have a fundamental right to have your freedom restored after you've finished your sentence of incarceration, and that indefinitely imprisoning people who cannot find housing was not a properly tailored way of advancing any legitimate state interests in public safety, rehabilitation, or anything else. And then finally, we said that this system of laws and policies violated the procedural due process clause in 3 different ways. First, people weren't being told why their host sites were being denied. So they would just get a slip of paper that said denied, and they wouldn't know why. They wouldn't even be told if there was a way that their family or their loved one on the outside could fix the problem and make the host site compliant. They would just be told it was denied, and they'd have no way to do anything about that. Second, if a host site was denied for an improper or wrong reason, there was no opportunity to appeal that or to take it to a higher authority and ask somebody else to take another look at it. And then finally, we claimed that this prohibition on living too near to all these different sites was just unfairly vague. It didn't give people fair notice of what could lead to denial of a host site. So, what happened in this lawsuit? Well, we litigated for about 2 years. The Department of Corrections took depositions of 4 people who were in this loop, unable to get out of prison because they couldn't find a host site. We submitted affidavits from about 35 or 40 other people who were also in this situation, describing their circumstances and what led to them being imprisoned. The Department of Corrections, let's take the deposition of their deputy chief of parole, who said, well, you're basically right. If somebody doesn't have money, too bad, they're here forever. And so we were ultimately successful. A few months ago, Judge Virginia Kendall of the United States District Court for the Northern District of Illinois granted summary judgment in our client's favor. I felt like giving her a round of applause too. So she found that these laws and policies were violating our client's rights under the Equal Protection Clause and the 8th Amendment. With regard to our procedural due process claim, she thought we needed to have a trial because it wasn't totally clear from the record whether there was any process for someone to challenge the denial of their host site. But I'll tell you a little bit more about that shortly. Ultimately, we do not have to go to trial on this. Here's what Judge Kendall wrote in her decision. The defendants have created separate consequences for indigent, homeless sex offenders and for non-indigent, non-homeless sex offenders. Only those who have no financial resources suffer a continued deprivation of liberty following the completion of their court-ordered term of incarceration for the original sex offense. The defendants are punishing the plaintiffs for their indigency and homelessness, matters totally beyond their control. Judge Kendall's decision was 61 pages long, and she issued it 2 weeks after the briefing was done. So we were very encouraged by that because it seems to me that she took it very seriously and realized what a problematic situation this was and what a serious violation of the Constitution it was. So where does that leave us now? Well, the Department of Corrections has decided they are not going to appeal. They want to sit down with us and start talking about how to solve this problem, how to get these folks out of prison, how to make sure this doesn't keep happening to people with indeterminate MSR in the future. It's a bit of a slow process. We had a meeting with the judge and with the attorneys for the Department of Corrections last month, and we gave them a wish list. What do we want you to do to fix this problem? And the answer is, we want a lot. We want you to do a lot of things and change a lot of these laws, a lot of these policies, change the way you're doing things. So we sent them our wish list of everything we thought they should do to start fixing this problem. And I'll review a couple of those things we asked for. First, we said, look, child-specific restrictions that are set forth by state law should not be applied to people whose offenses were against an adult victim. There's no statutory reason to apply that. There's no real logical reason to apply it either. Second, we said, get rid of this one registrant per address rule. We want them to repeal that law, ultimately, but if the judge will not order them to get rid of that law, we at least want it applied in the narrowest way possible, which is, okay, you can't live in the same apartment building as another registrant, but that should not be applied to trailer parks. That should not be applied to adjacent apartment buildings that happen to have the same owner. We next asked them to really reconsider how they're applying this electronic home detention requirement. Right now, people who are released from the Department of Corrections are put on both GPS and electronic home detention. So you wear a monitor that will record everywhere you go, and a monitor that will record whether you're within a certain distance of the beacon that is within the home. This is obviously duplicative. GPS would reveal all the same information about whether someone was where they were supposed to be or whether they were somewhere they shouldn't be. So get rid of this home detention requirement, put people on GPS, and that opens up a lot more options. For someone who doesn't have a place to live, they could use a shelter as their address, as their post site, and that would at least enable them to get a job, make money, or reestablish their eligibility for government benefits and have a chance of actually affording their own housing. So we're asking them to get rid of the electronic home detention and just replace it with pure GPS. Next, we think they should give people written reasons if they're going to deny their host sites. There should be an opportunity to appeal a denial of host site. Take it up the chain to someone with higher authority who can review whether this is actually a reasonable denial. So right now, we have no way of knowing why host sites are being denied. The person who's in prison doesn't know why, the family outside doesn't know why, and we as the lawyers don't know why. So we think it will make a huge difference in terms of accountability if these reasons have to be put in writing and there is some formalized review process to ask for somebody higher up to look at this. And then we had a lot of suggestions about how they should make transitional housing or halfway houses available to people. We said, look, you've got 1,300 people doing time in prison who don't need to be there. They should be in the community at their own housing, serving their mandatory supervised release. Redirect those funds. You are wasting millions of dollars every year imprisoning people. Use that money to help private charities open halfway houses. Use that money to operate Department of Corrections halfway houses. Close a prison and convert it into a halfway house. Or use the funds that you were using to operate that prison, to imprison these 1,300 people, and use those funds for community supervision, for some kind of transitional housing. And then finally, stop making it so difficult for private charities who might want to give people a place to live, to help them get back on their feet, to operate halfway houses. This is something that is within the department's discretion to change. It is up to them what satisfies the security requirements. So they should make that a lot easier, particularly if everyone who's going to be there is going to be on GPS anyway. Where are we at with this? Well, we have a few really positive things having happened. One is the Department of Corrections has agreed they will no longer apply the 500-foot rule to people whose offenses were not against minors. They will no longer apply the one registrant per address rule to trailer parks or adjacent apartment buildings. They will no longer prohibit people from going to host sites that have computers or internet access. And they will establish a reasonable review process that requires the parole agent to put down in writing why the host site is denied and give the person an opportunity to appeal. These are all really good things. And I feel like for the first time in my history of working on these issues for the past 5 years or so, that we actually have some power. They're actually listening to us for once. So when a family calls us and their loved one is in this situation of not being able to get out of prison, they are listening to those concerns and they are finding places. So we have already gotten maybe a dozen of these folks out. There is still a ton more work to do, and I think the most intractable problem is the lack of free housing. That there still isn't a way for people to go to a halfway house or some other place they don't have to pay for. So it is still very difficult for someone like Paul Murphy, who really doesn't have family on the outside who can pay for him, doesn't have money of his own. He's still stuck for now, but this case is not going anywhere until that problem is solved too. So there is some hope, and we're feeling encouraged that we will get all these folks out and we will stop this problem from continuing in the future. Now, I wish I could just end there and say, yay, great success, we've got these folks out and that fixes this problem. But unfortunately, what this case revealed is that even when we get folks out of prison and onto MSR in the community to serve their time, there's still major problems with how the state is administering that system. People are subjected to a host of very unreasonable and, to my mind, unconstitutional restrictions on their lives after they get out on MSR. So there remains a lot of work for us to do. We already have 2 lawsuits about unreasonable parole restrictions that are being imposed. So the first is about people's ability to have contact with their own minor children. Up until recently, the Illinois Department of Corrections imposed a blanket rule that said if you are on MSR for a sex offense, you are not allowed to have any contact with any child, including your own, for 6 months. And that was not just you're not allowed to be in the same home or live with your child. It wasn't just that you can't visit your child. They extended this prohibition to phone calls, birthday cards, even writing a note. Yes, it's beyond the pale. It is really shocking, really horrible. And this rule was being applied across the board to anyone who had any kind of sex offense conviction, whether it was against an adult, whether it was a non-contact offense involving illegal pornography, really regardless of what the conviction was for, this prohibition was being applied. We now have a preliminary injunction in place that says the department can no longer enforce that rule. It cannot be a blanket prohibition on contact with people's own children because you have a constitutionally protected right to a relationship within your family. I think we still have a lot of work to do to get that case to where it needs to be. I still think there's far too much power in the hands of the individual parole agent to decide how long this restriction will be imposed and how severely it will be imposed. I still don't think there's enough oversight of how that decision is being made. But we're making progress there. The other case we've filed is about internet access. Up until very recently, the Department of Corrections has imposed a rule that anyone on mandatory supervised release for a sex offense is prohibited from having any access to the internet whatsoever. It doesn't matter what the offense was. It doesn't matter if the offense had any connection to the use of a computer or the internet at all. It was a blanket rule. And relying on Packingham, which many people here have mentioned already this weekend, we have sued to say that's a violation of the First Amendment. If restrictions on internet access are going to be imposed, they have to have some reasonable nexus to actually preventing crime or aiding someone's rehabilitation, which this blanket rule doesn't. So the department is slowly changing that policy. I still think we have a long way to go there in terms of bringing that policy in line with constitutional requirements. It obviously greatly hinders someone's rehabilitation and reintegration into society if they can't use a computer to look for a job, continue their education, stay in touch with family who might be from out of town. So we're continuing to work on those two cases. More broadly, we have a serious problem in Illinois with the excessive discretion that is afforded to parole agents. Parole agents in Illinois make so many decisions with almost no oversight, and these decisions greatly affect how people can go about their lives once they're out of prison on mandatory supervised release. Parole agents dictate where you're allowed to work, who you're allowed to see, when and whether you're allowed to leave your own home, whether you're allowed to go to church, where you can shop for your groceries. And people who are on MSR for sex offenses are completely at the mercy of their individual parole agent. There is no way to appeal a decision made by a parole agent, no matter how extreme or ridiculous it is. We have clients who've been prohibited from going to church, prohibited from going to AA meetings that they've been attending for years. And there's nothing you can do. There is no one looking over these parole agents. So I think that it's a very serious structural problem in Illinois that we're monitoring closely and we want to address. So as these 250, 300 people start to get out of prison and start to serve their MSR time in the community, we're working with them, and we want to bring that whole system of parole agent discretion in line with constitutional restraints. Okay, next. We have a serious problem. We do not know how to get off of 3 years to life of supervision. There is not a clear standard. There is not a clear set of criteria. There is not a clear process. How does someone who's been living in the community without committing any new offense, without committing any parole violations, ever get off MSR? It's unclear right now. There is a supposed level system, but where you're supposed to go from level A to level D, and then after level D, you're supposed to have an opportunity to terminate it. We're not aware of anyone actually successfully navigating that system, and we are aware of people who've been on mandatory supervised release with no violations whatsoever for 7 or 8 years. So how do you end this? I think that is the next frontier that is faced by all the members of our class who are now getting out of IDOC and starting their MSR time in the community. This system needs to be reformed. There needs to be clear criteria, clear standards, clear process to follow to end this supervision. It shouldn't be in the hands of the parole agent to decide how much punishment you get. And then, I think that the principles that were enunciated by Judge Kendall in her decision need to be applied more broadly. What she said is that it's unconstitutional to keep someone in prison just because they're too poor to afford housing. That should be uncontroversial, but as we know, there are over 1,000 people who are not members of our class who are doing exactly that. They are in prison because they can't find a host site or they can't afford to pay for one. So I think that the logic of Judge Kendall's decision needs to be applied to those people too. And we need to start changing this system of people just maxing out their MSR time in the custody of the Department of Corrections. I also think that this should be applied to people who have been approved for release from civil commitment. So if someone's been civilly committed and they've found the person is no longer a severe danger to the community and should be allowed to go into private housing and out of the custody of the Department of Corrections, they need to find housing too. Well, we shouldn't be imprisoning them just because they can't find a place to live that complies with all the restrictions. So there's a lot of frontiers that were left open by this small victory that we had, and we are still committed to seeing through all of these issues over the next couple of years as our clients start to serve their time in the community. As I was getting ready for this talk, I talked a lot with my co-counsel Mark Weinberg, who I worked on this case with, about whether there was a way for me to end on a positive note and say, change is coming, tide's turning, we're gonna win, and have that be true. And there are plenty of reasons to think, that's not really the right way to end this talk, because obviously we won our case, but it revealed all of these very serious constitutional problems, all of these very serious constitutional abuses that are still ongoing, and still out there that all of our clients are going to be subjected to. It's not an easy situation for them, even once they get out of prison. But even given all of that, I think that there is reason for optimism and there is reason for hope. I think our case is a good example of how change can happen, is that we took this discrete problem faced by this group of people, we brought it to a federal judge, we gave her real life examples of how people's lives were being destroyed by these laws and policies, and she took it very seriously. This is not a bleeding heart hippie judge. She is a George W. Bush appointee, but she understood the case and its significance, and she issued a very powerful decision protecting the constitutional rights of our clients. So that is encouraging. And as Janice mentioned earlier today, almost every month we are seeing encouraging decisions from around the country. The Alaska Supreme Court decision yesterday, a great source of hope. And I think that more courts are becoming sensitive to these issues and are willing to give them a really serious look. So I guess what I want to say is we don't know how soon change will come. We don't know where the change will come from or how it will ultimately come about. But I think with the efforts of everyone who's here at this conference, there is real potential to turn the tide. And so I just hope that we'll all keep up the fight, keep the faith.